Tuesday, once again, today we're talking about threats on social media and whether or not they're protected under the First Amendment right of free speech. The Supreme Court is tackling the issue this week. Attorney David Ayler, one of the 7 wonders of the World Wide Web himself, here to do the same. Counselor, thanks so much for being here. We see this all the time. Cyberbullying, it's in the headlines just about every week right now. Kids bullying other kids, forcing them to do some really terrible things. So where does the law fall on this issue?
Well, this is an interesting situation that's going to be in front of the Supreme Court. And the decisions that have come prior in the different courts, including lower federal courts, is that if a person feels that a threat that you are making against them on social media, Facebook, Twitter, WhatsApp, whatever it may be, if they feel that it's a valid and a logical threat, then you can actually be arrested for it and prosecuted, and that's what's happened here. Now, I want people to understand we're not at all talking about your opinion of a restaurant or your opinion of a person. Somebody is a liar, someone is a bad person, whatever. That's completely separate. That, of course, is going to be protected under the First Amendment.
Talking about is threat of physical violence.
Exactly, some actual threat of some sort of physical violence to the person. No different than if you were in some sort of public setting and said it to them. Obviously, a lot of people don't understand that you can get arrested for that. Again, for that same standard as if the person themselves feel like that they're actually have the threat and should logically feel concerned about that. And that's what's happened in this case. It's an ex-wife with an ex-husband, and he's made the threats. And of course, from the side of it with his defense attorneys and a lot of national critics on it, they look at it as freedom of speech. First Amendment should be protected, and that's what he was doing, making a rap, whatever it may have been, and that should be protected. But we'll wait and see what the court says.
So where does this fall? Because I think a lot of us that scroll through our news feeds each and every day have that 1 or 2 people that may have split from their marriage or relationship, and they say some pretty nasty things each and every day. So where do you draw the line on this? Of course, is it all those people going to be held accountable, or is it just whoever comes forward and said, well, I feel threatened?
Well, I think you have to look at sort of what realm you're in. For instance, we see now in family court throughout every state, issues with Facebook and comments from Facebook that people, bring in as evidence, and that gets used constantly, pictures and things like that. Also with jobs, we've talked about it on here before, people that lose their jobs because of statements they make, whether they be political or, something harsh with profane language, whatever it may be. But what we're talking about specifically here is when someone is making a physical threat to another person. Now, if that person, let's say, is in Montana and someone from Charleston makes a threat, is it really logical to think that they're coming after him that night or that sort of thing? So it's really going to pretend specific to the situation. But what's important is if in fact the Supreme Court decides that just because it's on social media that doesn't take away the fact that it's a real threat, then the First Amendment will sort of have to take a back seat to the assault charges.
And Counselor, where does that cyberbullying stand? Because sometimes, especially when it comes to the case of adolescent girls, it's not so much the threat of, well, I'm going to physically harm you. It's you should physically harm yourself because you're this, or you're A, you're B, you're Z.
And that's an interesting point too, because you see a lot of these. I know there's been some cases in Florida where the cyberbullying and people have been prosecuted for it. That a lot of times has it whether or not it's been directed to you. If you just make a statement about another person or some sort of negative comment, that's a little bit different than when a lot of these times where they've targeted the person, they've tagged them, they've sent them a message, they've posted it to where that person would be made aware of it, as opposed to, of course, just making a blanket statement about the person.
So it's really important to note that while everyone thinks that Facebook is this, autonomous floating thing where it's your space and you get to be private and say whatever you want, really it's not. And even in fact, a court of law, a judge can come after you for statements that you make on social media.
Well, the first thing is not as private under any circumstances. No matter if you think it's private because you've limited your friend group or closed group, it's not private. It can be subpoenaed and is used in all types of cases. But when it comes down to the threat specifically, the Supreme Court's going to make that decision. If you decide to make a threat to someone else, if it's legitimate, you're probably going to get arrested.
So this goes back to, media ethics classes and that fire in a burning theater shouting that. Is that kind of the same statute? Are they using that case for this appeal?
That's a lot of the critics are making that argument as well. And yes, because again, it looks to whether or not it's a logical threat. And in this situation so far, the courts have decided that it was. The Supreme Court will make the final decision.
All right. Always important to note that social media, again, not private. A lot of people can read that. You can be subpoenaed as well. David Ayler, thank you for your time, sir.
Thanks for having me.
Do appreciate it as always. Much more Lowcountry Live coming your way next. Stay with us.
Trial Tuesday, brought to you by attorney David Ayler.